A few years back, I rewarded myself by purchasing all 11 seasons of the British television series Who Do You Think You Are on DVD. This show served as a prototype for the American version that a lot of us are familiar with and which has been featured on NBC and TLC, but I considered the British version much superior to ours. The programs are over 50 minutes in length, and without the necessity for commercial breaks, there's time to show the complexity and variety of sources and locations involved in completing the featured celebrities' pedigrees. Of course, I've never even heard of some of these individuals, but they are reasonably well known in the UK, and they seem quite prosperous and successful. One thing that really amazed me is the fact that just a few generations ago, many of the British celebrities' ancestors were struggling in a morass of the deepest, direst poverty. Some were involved in trades or crafts that had been overtaken by industrialization or free trade legislation. There are tales of bastardy, seniors spending their retirement in workhouses because they were impoverished and their children could not afford to maintain them. Endless hours of back-breaking toil in factories, on the docks, down the mines, industrial accidents and workplace health hazards, crowded crime or disease-ridden tenements, evictions from landed estates, servitude in great houses, and miserable death on the front lines of World War I. I can't help but think about my own very modest ancestry in the United States and how it compares with the experience I'm seeing on Who Do You Think You Are? Few of my forebears were as miserable as this. Of course, none of them lived in the industrial cities of the Northeast and Midwest during the Gilded Age, or in a mining town in the Appalachians. Conditions in these places could compete with anything experienced by British workers. But I wondered what made the difference for my southern rural ancestors, and it occurred to me that the real distinguishing factor was the widespread availability of land up through the mid-19th century for white Southerners. My ancestors owned modest farms of a few hundred acres each. They raised large families, but most of the children, when they grew up, moved away and found new land elsewhere. As long as they shepherded their resources carefully, no one went hungry. Few of them ended up on poor relief. They were proud of their self-sufficiency, but their ability to maintain their independence rested on the sturdy foundation of land ownership. It seems to me that the growth of the welfare state in the early 20th century came about primarily because open door to land ownership was gradually being bricked up at that time. Its insufficiency was dramatically demonstrated when the Depression struck. The frontier was closed and people were moving to the cities. They did not have the land to support them in their old age anymore. Families were becoming more fragmented. Technology changed the farm economy, and less labor was required in agriculture. Some alternative to land as a safety net was in order. Extreme poverty in Britain brought similar changes there at about the same time with the rise of the Labor and Socialist parties. Some would say the United States even owes its democracy to widespread distribution of land. Once people owned significant property, they became subject to taxation and wanted a say in government. The key to independence and dignity lay in land ownership. I think there's a lot of merit in that notion. In former times, conditions for ordinary people were much more constrained. In the Middle Ages, land ownership was mostly restricted to the upper classes, primarily to the aristocracy, the ecclesiastical hierarchy, and the gentry. The crown had ultimate title to all land within the realm, and the great magnates, or lords, held their property directly by grant from His Majesty. In exchange, they provided the king with military assistance, counsel, and money when he required it. If they failed to perform their duties to the king or were found to be guilty of high crimes against the state, the land could be forfeited back to the crown. The same could happen if a time came when there were no longer heirs. In turn, the great lords parceled out their lands among their own followers in exchange for similar services, and this chain of dependency could continue to subdivide plots on down to the lesser lords through a process called sub-infeudation. Most ordinary people, however, lived on the manors of individual lords. They owned no land at all, but worked on the lord's portion of his estate, called his domain, in exchange for the use of small plots for their own subsistence. These strips were subdivided and redistributed every year so that everyone had roughly equal access to quality land. They paid dues to the lord at particular times of the year, at landmark events in the lord's life, or when one tenant died and his son took his place. They paid fees for using his mill or oven in addition to tithes for the support of the clergy. They were subject to his justice and had to serve as armed retainers when required. In exchange, he provided them with protection and a secure living. Some categories of tenants, called villeins, were restricted from leaving the manor at all. Some people did flee the manorial system once towns began to grow. With the revival of urban centers, commerce gradually enriched persons of very modest background who worked as artisans or traders. The system really began to turn upside down, however, when the Black Death ravaged the British Isles in the mid-14th century, and actually the entirety of Europe. About a third to maybe even a half of the population in some places was wiped out in a matter of a few years or decades. That meant that the survivors, even some people of very limited means and humble background, suddenly had more resources, much of it received by inheritance from deceased relatives. Laborers were at a premium because they were suddenly quite scarce. Peasants could then begin to demand better terms for their labor. They could threaten to move away and let a manor go to waste. Some folks accumulated enough means to begin to acquire small tracts of land for themselves. Through the 15th and into the 16th centuries, more and more commoners owned land in their own right. The costs of the Wars of the Roses exhausted many noble families financially, forcing them to sell property. When Henry VIII overturned the Catholic Church and dissolved the monasteries, even more land was suddenly available for redistribution. The Crown also fostered a new class of bureaucrats and professionals of modest background, while increased commerce with other countries strengthened the merchant classes. Many of these nouveaux riches had aspirations to become country gentlemen and own their own farms. However, for the masses, land remained out of reach. As the 16th century drew to a close, rapid rises in population coupled with high inflation had led to devastating effects on England's rural economy. Many landlords decided to break their old paternalist social compact with the manorial tenants. The pinch of inflation caused them to raise rents and convert more land to pasture for flocks, which were more remunerative and less labor-intensive than crop growing. Tenants were evicted when they could no longer afford the rents. The vagrants wandered the roads, were harried from place to place, and some ended up in grinding poverty in the cities. These late medieval and early modern changes in land tenure lay behind much of the migration to the American colonies beginning in the early 17th century. Here, for the first time in history, lower-class Englishmen had this potential to own land absolutely in their own right. Of course, the problem in America was quite different. Here, there was no need to attract immigrants who would risk their lives and capital on a transatlantic journey. Land was plentiful, so it was used to induce colonists to take these risks. Anyone who paid passage and imported an individual into Virginia was able to get 50 acres per person, called a headright. A similar system prevailed in North Carolina from the late 17th century until 1754. Purchase patents, however, predominated in this state. Such patents were allowed individuals in exchange for cash and were granted either by the crown, who just as in England held ultimate title to the land, or by proprietors who had been rewarded for services rendered to the state, mostly supported of royal government during the Commonwealth period of the 1650s, with huge grants of land in America. In the case of the proprietors, these tracts enriched both the first grantees and their heirs for many generations. Think, for instance, of William Penn in Pennsylvania, Lord Baltimore in Maryland, Lord Fairfax in the North Neck of Virginia, or the 8 original proprietors of Carolina, the last of whom to lose his rights was Lord Granville at the time of the Revolutionary War. In every colony, there were one or more land offices where people could apply for grants. Sometimes those offices were operated by a proprietor's representative or agent. When the Crown was granting land, it was usually done through a member of the Royal Governor's Council of State, usually the Secretary of State. The later state land grants that were issued after the Revolution followed more or less the same procedure and also involved the Secretary of State. Now let's talk about the stages in the grant process. The first stage is the entry stage. At this point, an individual desiring land located a tract of interest that was apparently vacant. He gave a description into the office, or perhaps through the county surveyor, who entered that description into the entry book and forwarded a copy to the office where a second entry book was kept. Next came the warrant phase. At that point, the office would compare the entry submitted against other requests in its custody. It was supposed to search for overlaps or direct conflicts between grants, and if there was none at all, then it would issue a warrant for the land in question to be surveyed. The warrant was basically permission to continue with the process. The standard waiting period between entry and warrant was 3 months to allow any conflict or objections to come to light. Next came the survey. The local surveyor measured off the property with 2 chain carriers to stretch the chain used to measure the dimensions. He blazed the trees or marked them in a unique way that they were going to use as corners. He drew a plat and wrote a detailed description. A plat is a graphic representation or drawing of the tract, giving the lengths of each side, the corner locations, and the degrees and directions turned at each corner. These were called the courses. These surveys could also mention neighbors or natural landmarks. The survey was paid for by the person desiring the land, called the grantee. It was returned to the land office along with the warrant, which the office then filed. Next came the grant. Once the fees had been paid, the land office would issue a grant with the official seal of the state, proprietor, or colony affixed, and the governor's or proprietary agent's signature. The agent or secretary would then send the final document to the grantee. He might also enter a notation or copy of the grant into his own patent, grant, or record book. The grantee now had title to the land. And there was sometimes a final step. Once he had received a grant, it usually seemed reasonable for the person obtaining the land to record it in a deed book of the county in which it was located. That allowed a local public record to be made in case the original grant should be lost for whatever reason. An additional fee was due to the clerk of court for making the record. Remember that land grants could also be issued by the state to reward soldiers for military service. Bounty grants were issued by state governments and by the federal government after the Revolution. Those lands were given in exchange for continental, not militia service, based on the length of service and the final rank of the soldier. All bounty grants were located in the West, beyond the Appalachians. North Carolina bounty land warrants were issued in the state of Tennessee, and they ceased when North Carolina ceded its western lands to the federal government in 1790. After that, the state of Tennessee was formed. When any bounty land was issued after that by North Carolina, it had to go through the offices in Tennessee to be finalized. Likewise, land could be stripped from an individual for treason, just as in England by a bill of attainder. Confiscation committees were established in North Carolina at the end of the Revolution to recover land held by enemies of the state. Usually, only the most notorious, most unrepentant, or unconnected, or the wealthiest Tories had their land confiscated, particularly Lord Granville and Henry Eustace McCulloch. Proceeds from the resale of confiscated land went to the benefit of the University of North Carolina. We need to remember that the colonial grant process was often difficult for people to bring to completion. There were great distances involved because counties were large and courthouses and land offices were far away. Roads were poor. Some of the land offices were riddled with corruption and venality. Granville's office was particularly deficient in this regard. You had to grease the palms of officials at every stage in the process, sometimes paying 2 or 3 times the stipulated fees. Furthermore, at various periods, land offices were closed, and it was impossible to bring a grant to completion. This happened at Granville's office in 1763, when the second Earl died and his estate was contested among his heirs. His office closed at that time and it never reopened. The third Earl died in 1774, just as he was making preparations to restore the office. Next, the Revolution broke out, and the Granville lands were confiscated by the state of North Carolina in 1777 or 78. Even earlier, there was some confusion between Granville and Henry Eustace McCulloch, another royal grantee, who was awarded land in 12 great tracts, partially overlapping with Granville's district. Ultimately, Granville and McCulloch came to a settlement between 1755 and 1761. According to its terms, McCulloch would receive the consideration for the lands that he granted in Granville's territory, while Granville's office would issue the paperwork and receive the resulting fees and quittance. The period of time in which McCulloch could make grants was also limited, although he got an extension due to the disruptions caused by a war with the Cherokee in the 1760s. Whatever land he didn't sell during that time period would revert entirely to Granville. Because of these ambiguous circumstances, folks often occupied vacant land without ever obtaining a grant for it. Neighbors may have assumed it was theirs, and they may have even paid taxes on it without legally owning it. Later, they may have moved on. They may even have sold the value of their improvements, that is, the house or the outbuildings, fencing, improvement on the ground, to a subsequent individual who then obtained the grant. The deeds or grants of these later individuals may mention the sale of the improvement. So the deeds could mention some improvement made on the property, like William Bennett's old cabin. But who was William Bennett? Well, he was probably the man who settled there first, but never actually owned the land. The conditions of grants varied from time to time and from place to place, but generally, in order to hold on to a grant from the state, an individual had to settle on it or improve a certain amount of the land within a specified period of time. The hope was to discourage speculators who merely wanted to just sweep up a lot of land and then sell it all for a profit to smallholders. Authorities also wanted to make sure that the land was settled and that the colony was strong enough to support its government and resist Spaniards, the French, and the Indians. Usually, speculators were able to turn the property quickly enough to avoid losing it, but occasionally you will see references to land that has escheated back to the sovereign. This usually happened when someone died without heirs or simply left the colony and abandoned the land. Each colony had an escheator, who was an officer appointed to inquire into these situations and rule on them. Escheated or reverted land could then be regranted to somebody else. Land grants are extremely valuable as records. They are the first link in any chain of title. When you come across an old cache of deeds among the family papers, any land grants that appear are usually the oldest documents. The surveys in the secretary or proprietor's office are usually useful because they describe the land and give chain carriers, or sworn chain carriers they're sometimes called, who are sometimes relatives, often sons, brothers, fathers, nephews, cousins, or friends and neighbors of the grantee. If you look on the reverse of the warrant or survey, you sometimes will find that the original grantee signed away or assigned his rights to another person even before the process was completed. So the grant is sometimes issued in the name of someone other than the person who made the land entry. Sometimes these two people are related. Witnesses to these transfers are also given, and their names too may be significant. Of course, there are always the problems of conflicting titles to grants and overlapping grants. A caveat could be issued in favor of anyone who had a competing claim to a land entry during the period between the entry and the issuance of the warrant. These conflicts would often need to be settled by arbitration or by a jury trial on the land. Title was in question until the caveat was settled. Sometimes the testimony in such a case is extremely revealing. Petitions to the governor could potentially stay a grant from the time the warrant was issued until he signed the finished patent. Even after the grant was made, boundary conflicts could arise and result in litigation, usually in the superior court, often sitting as an equity court. The cases could drag out for years and generate a lot of testimony based on the remembrance of friends, relatives, and neighbors. So where will you find the state land grant records? The original warrants and surveys from the Secretary of State's office are located at the State Archives in Raleigh. They're not available for research because of their fragile state in their original form, but you can use the microfilm to view them. They are organized by county and then by grant number. There's a card file at the archives so that you can determine what the grant number is. But the land grants are also indexed in the cataloging system of the archives, and better still, because it's much more user-friendly, on David McCorkle's website, North Carolina Land Grants, Images and Data. You can also find them, for the most part, digitized on Ancestry.com in a separate database, all their own North Carolina land grants. Digital images of the early state-level grants books and images of land warrants and surveys are gradually being attached to the index records on McCorkle's site, and more counties are being added all the time. Now let's talk a little bit about tenures in land. Tenure is defined simply as the terms under which somebody enjoys the right associated with land ownership. But there were different varieties of tenure prevailing at different times in history. In England, tenures were more restricted because society wanted to ensure the stability of land ownership, and thus the very foundation of the economy across generations. Land was the principal source of wealth, and it was thought undesirable to allow the poor decisions of one heir in the chain of descent to destroy the chances of the next generation. Therefore, until 1540, it was impossible to devise land in your will. Real estate was expected to follow a fixed line of descent. Many people who acquired land and had absolute rights to it wanted to ensure that their heirs could not get rid of it, so they might entail it when they passed it to the next generation, meaning that it could not be sold. It had to pass to the next heir in perpetuity along a lineage specified in the document, usually the eldest son. Land held in this way was said to be held in fee tail. Typically, terminology for entailment would pass land to someone and to his heirs male forever. The middling and poorer people in England tended to hold land at the sufferance of the lord of a manor. Some of these tenants had hereditary rights to pass this land on to their children, or the right to sell or lease their right to use it to a third party, but the lord was due a premium at each transfer of the property and retained his other customary prerogatives, including the ultimate title to it, mineral rights, and rights of way. It remained ultimately the lord's property and would revert to him if the family failed to live up to its obligations or died out. Such a land tenure is called a freehold. Other tenants who held by copyhold on the manor were more restricted. They held the land for a term of years at certain premium and rental payments. Their heirs were not guaranteed the property at their deaths, but as long as the lord was satisfied, he would give the heir a copy of an entry on the manorial rolls showing the transfer from father to son for a fee and continuing rental payments. Copyhold tenants had to have the lord's agreement to sell their interest to somebody else. And then other land was held by lease from the original owner for a specified number of years, often 99 years, or a number of lives, usually longest lived of 3 lives, in exchange for a premium and rents. These were outright leases, but usually on easy terms. After that period of time, unless the lease was renewed, the land reverted to the original owner, the lord of the manor. The simplest and most unencumbered form of land tenure was fee simple ownership, and that was the variety that prevailed later in America, because land was so plentiful. A fee simple owner has absolute rights to do with his land as he pleases. He can sell it, lease it, will it, or give it to anybody, as long as he pays his taxes and satisfies his creditors. However, through the end of the Revolution, it was possible for a fee simple owner to entail his property down a particular line of descent. Only the legislature, or later certain specified courts, could break the entail. This is called the docking of entails. Because entail was associated with aristocracy, the revolutionary generation abhorred it, and it was abolished in North Carolina in 1784. Typical language for a fee simple passage of land from one party to another would grant it to him, that is the grantee, and his heirs, designates and assigns. Now, how about inheritance as a way to pass along real estate? Well, for people who died testate or with a will, first of all, besides conveying property by a deed, a bargain and sale, or leasing it, that was another common way for land to change hands through inheritance. There's some restrictions on how such property could be conveyed. We've seen how entail or local custom could restrict inheritance of landed estate to one line of descent through the male or female line. Land that was inherited as one's patrimony from ancestors might be restricted in this way, while land acquired by the deceased person during his lifetime, including freehold tenures and leases, could be passed to whomever he pleased. The only ironclad and persistent restriction in America with regard to wills and real estate was the widow's dower right. A widow was entitled to enjoy 1/3 of her husband's lands for the remainder of her life. It was for her use and upkeep, but it did not belong to her outright. Therefore, she had to take good care of it and pass it on to her husband's heirs at his death, or her death, rather. She could lease it to someone else, but only for her lifetime. She could not sell it. She could not misuse it and diminish its value, except to the extent absolutely necessary to support herself and her minor children. A husband might try to leave his wife some lesser quantity of property, including perhaps land, outright if she would renounce her dower. If she accepted, this property that she had inherited from him would be hers alone, to do with as she pleased, but whether she accepted or not was up to her. If she demanded her dower, no matter what the will said, she could take exception to the will, and this is called a descent, and the dower land was to be laid off to her. A commission of unrelated, impartial people would be appointed to do this. There's another element of dower law. Before the Revolution, it was also a woman's right to give consent to any sale of property her husband made in North Carolina. She was effectively signing away her dower rights that would come to full effect when he died. This right, called common law dower or inchoate dower, was abolished in 1784, but it was restored again in 1868 in North Carolina. During that interval, the only land a woman had to sign away in concert with her husband was property that came to the marriage through her. Now, what if a person died without a will? If a person died without giving specific directives about his or her land in a last will and testament, state laws, called laws of intestacy, determined who would receive it. In the colonial period, it was the eldest male heir of the deceased. The younger sons and the daughters were cut out. Only if he had no surviving sons or grandsons through his deceased sons would land descend to daughters. If the deceased person was childless, his eldest brother or eldest nephew through the male line might inherit. Some colonies had different customs, but this system favoring the eldest son, which was called primogeniture, prevailed in the southern region. In some other places like Pennsylvania, all the children, even in the colonial period, received a portion of the real estate, but the eldest son received a larger share than the others. After the Revolution, primogeniture fell out of favor. It was eventually abolished in North Carolina. From 1784 until 1795, anyone who died during that period, the laws provided that all the sons, but no daughters, would share in the land of an intestate decedent equally. After 1795, all the children, regardless of gender, had an equal share in landed inheritance. Primogeniture often happened with little fanfare, and so it sometimes leaves little trace in the records. Possession documented through later deeds is sometimes the only way to detect that it has taken place. For instance, any real estate that a dying person did not explicitly bequeath to others went to his eldest son, even if that son's name never appeared in the will. The estates of men who died without wills rarely even mentioned their land in the colonial period. It simply passed along the lineage required by law. After 1795, under the new regime of partible inheritance, however, land could be held undivided among all the heirs for quite a long time after the intestate owner had died. This often happened because there were minor children, because the widow was still alive and residing there, or because all the children were living amicably on or near the land. During this period, before the division, they were called tenants in common. Someone would then have to apply to the court so that it would order a division. The petitioner was usually one of the children, often one who had come of age just recently, or married, or the administrator of the estate. The administrator might decide to petition the court because there were debts to be paid that couldn't be covered by selling personal property. Even a creditor's account or a court judgment against one of the heirs might be satisfied by an application to sell the debtor's interest in a landed estate, and the creditor or sheriff would then apply to make a division. There were two ways to effect a division. In one of these, land could be divided into actual pieces and distributed among the heirs, such as you see in this document. The court would appoint a commission of disinterested neighbors to allot portions to each of the children and the widow, though her dower was often laid off immediately upon the husband's death. The portions were not exactly the same size. An effort was usually made to divide the land sensibly into plots that could be resold later. An attempt was made to equalize the value of the land in each dividend, as it was called, each part of the division. But when one parcel exceeded the average value, the heir it was allotted to had to compensate all the other heirs assigned portions of lesser value with a monetary payment. Each heir could then hold his own portion in what is called severalty, in fee simple. And then the other method was when the land was of such minimal size or poor quality and the heirs so numerous that it would have been impractical to divide it actually. In that case, an administrator might ask to sell the whole tract as one piece and then divide the proceeds from the sale among the heirs share and share alike after any costs or debts were paid. This was a much easier process. The land would be sold at auction after being suitably advertised. The administrator would then report the sale and the money achieved, account for all the costs and debts, and submit his final report of the division of the proceeds, which might or might not list all the heirs. The reports of land division were often recorded in deed books, but not always. One should also check estate papers under the former deceased owner's name, or even civil action papers from the time period when the land would have been divided. And there are sometimes special books in which land divisions are recorded all their own. This is probably a good place in our discussion to pause and look at the ways in which our ancestors measured and laid off their land. In the state of North Carolina and most eastern seaboard states, land was measured by what we call metes and bounds. This is an imprecise way of measuring land. You may know that in more westerly states, Florida, the Midwest, the Deep South, and further west, we have federal land states where the federal government controlled land grants and laid off all land using a grid system with fixed meridians and baselines in place to guide the surveyor. Land was divided into townships of 36 square miles, composed of 36 sections of 640 acres each, which were then divided quadrilaterally into smaller sections of 320 acres, 160, 80, 40, or some increment of 5 acres. All the townships were numbered by range and direction from the principal meridian, and it's easy to position the land you're looking for by its description. This is a very rational system. Since it's laid off geographically against degrees of longitude and latitude, the land is precisely positioned. No one can be in any doubt about boundaries. Note that it was only possible because this was vacant land, aside from the Native Americans who weren't counted, unfortunately, and all in the possession of the sovereign authority, the federal government. In a long settled area, a grid system would be almost unimaginable. Metes and bounds measurement follows the contours of the land, on the other hand, taking note of natural markers which are easily moved or decay over time. So you start with a certain point and define it by a natural object, a marked tree, a stake, or a stone. You describe the angle and direction turned at the corners, which we call the courses, and the distances traveled between them. A chain of fixed length is stretched along a sighted line to give you the measurements of the sides. References to the established boundaries of other properties are sometimes made. Boundaries are also sometimes formed by streams or rivers or by roads. The quantity of land contained within the boundaries of the survey is often just an estimate, and errors can arise in the process. The location of magnetic north is not always the same, for example. It fluctuates with variations in the Earth's magnetic field. Corners of existing surveys can be misidentified. Stream beds can change course, and old marked corners can disappear. Needless to say, a lot of litigation arose because of inexact metes and bounds surveys. It kept the lawyers and the surveyors very busy. In some places, land was processioned regularly to avoid the pitfalls of the system and re-establish boundaries. The vestries in Virginia arranged for this on a regular basis, part of the parish apparatus of ecclesiastical government. But in North Carolina, it usually happened when a controversy arose or one of the owners requested or paid for it. Here are the units of measurement used in the metes and bounds system. The first set are lengths, and the second are values of area. If you establish a fixed scale, you can extract these proportions from deeds and grants, and using a protractor and ruler, or some graph paper, plot the metes and bounds described for each tract. There are even computer programs like DeedMapper that will do the mapping for you if you enter the lengths and courses accurately. You end up with pieces of a jigsaw that you can then position against a modern geological survey map of the area. You only need one fixed point in the plat that you can place exactly on a modern map in order to position the entire set of tracts accurately. That's on a theoretical level, by the way. You can create plats of entire neighborhoods and find who owned land there at various points in time and how the tracts were laid out in relation to one another. However, this is not quite as easy as it may seem, even with modern tools. I unfortunately don't have an iota of a surveyor's instinct in my body. The main way in which land was transferred in the United States, apart from patents issued by the state, were conveyances from a prior owner to a subsequent owner. This was usually effected by means of a deed of bargain and sale, in which the entire estate in land was passed in fee simple to the new owner in exchange for something of significant value. Usually this conveyance was unconditional, but sometimes you'll run into some stipulation, as when mineral rights or a right of way or fishing rights are retained by the person who's selling the land. Sometimes a graveyard is accepted from the tract so that the family can still visit and maintain it. Let's review briefly the main parts of a deed, also sometimes referred to as the record of main conveyance, MESNE conveyance, using this example. So a deed begins by identifying the grantor or vendor, the person selling or giving the property, and the grantee or vendee, the person buying or receiving the property. Their occupations and residences are sometimes given. The date of the transaction marks the effective point at which the transfer has been made. It's usually either at the very beginning or at the very end of the deed, and here it's underlined in orange. It is the 10th day of September in the year 1781. The grantor is John Crabtree, underlined in green, Jr. of Guilford County, and the grantee, underlined in blue, is looks like William Henderson, maybe, the son of Jacob. Oh, it's Henshaw, William Henshaw, the son of Jacob Henshaw. Next comes the consideration. That is the payment or satisfaction that is made from the seller to the buyer. That payment was not always made up front. Sometimes it was to be paid by a certain date. The amount of the consideration gives you an idea of the extent and quality of the land. Sometimes, however, consideration can be for love or natural affection, or for a small nominal sum, $1, 5 shillings. That usually means it's more or less a gift. Land can even be given to a younger family member in exchange for continued maintenance and support of an older relative for his lifetime. That maintenance would constitute the consideration. Then comes the description of the land. The courses and lengths of the boundaries are given with the corner identifiers. Neighbors may be given as well as some landmarks. Description may extend to a bit of the tract history of the land. The person from whom the grantor purchased or inherited it may be identified. The date of a previous purchase may be given, sometimes with a deed book reference. Or the description may reference the original grant and skip how exactly it came into the present seller's hands. If the word moiety is used, it suggests that the tract in question is a proportional part of a larger tract that was earlier subdivided in some way, perhaps by division or inheritance. You may also see references to individuals living on the tract who are not owners of it in this portion. These are tenants or lessees, and their names are hard to come by except in some of these deeds. After that, you'll find the warranty portion of the deed, which is basically boilerplate language stating that the seller conveys all his interest in the property and that he has legal title to it and will defend that title on behalf of the purchaser should it ever come into question. Of course, a deed's validity depends in part on whether the seller's title is good or not. As always, the buyer must beware. He must be assured that the person selling is competent mentally and in terms of age, in terms of ownership, to execute a deed and properly vested with the title before he hands over his consideration. And finally, the seller signs and seals his conveyance. If inchoate dower applies, the wife of the grantor may also have to sign, and she will be examined by an officer of the court separate from her husband when the deed is brought for recording to make sure that her assent is willful and unforced. 2 witnesses in the lower left-hand corner here at least usually sign with him. These names can be important to your research. The witnesses are neighbors, friends, business associates, or relatives of the parties. Witnesses to deeds had to be above the age of discretion, 14 years of age, in keeping with the common law. The grantor then hands over the deed to the purchaser. That conveyance is important because it's called delivery. Without willful delivery from buyer to seller, the transaction is not complete. I can deed my property to anyone, lock the deed in a strongbox, and the property is still mine until I actually hand over the instrument to the grantee. The wax sealing was a customary indicator of delivery. The last part of the deed is the probate information. Now, the probate process involves recording or proving the deed and putting it in a deed book. The grantee takes the deed into court. He proves the deed either by producing one of the witnesses or by bringing the grantor into court with him. The deed is accepted if the grantor or seller, giver of the land, acknowledges that he did sign and deliver the deed, or if one of the witnesses, who's called the jurat, abbreviated JUR, and you can see that here in blue, highlight, swears that he saw the grantor's signature applied to the deed. Sometimes a third person will attest to the validity of the signatures, naturally someone who is familiar with their handwriting. Now that usually happens because the original witnesses and grantor have died or are otherwise beyond the reach of the court. When people delay recording their deeds, this type of attestation becomes necessary, and it can sometimes help us to find when a grantor or witness died. Then a fee is paid to the clerk. Once the book copy is made, the original deed is returned to the grantee and is held among his personal papers. Deeds were often recorded at the end of each term of court in the minutes. You'll see long lists of them at the end of each quarterly term's notations. However, I will caution you that it does seem on several occasions that a deed ordered recorded in the court minutes does not appear anywhere in a deed book. Some clerks apparently were not careful in recording all the deeds submitted to them. So those lists of recorded deeds at the end of court minute terms are very useful sometimes. And that's what this looks like. The probate in the court minutes. Long list of the different people who brought their deeds in for sale, the witnesses who came in to prove them, or the acknowledgement. And sometimes here, even the amount of the land is put down in this case from, I think, Guilford County Deeds, court minutes. Now in England, there was no universal requirement to record land transactions until the 19th and 20th centuries. Most land conveyances were not enshrined in public records unless a legal issue arose. Definitely, deeds and other conveyances were created and passed from seller, the grantor, to buyer, the grantee, but they remained in private hands. When one person sold his interest in a property absolutely, he would turn over all the documentation in the chain of title to the buyer, and that person and his heirs would hold on to it until it was alienated out of that family, at which time all the documents in the chain of title would be passed to the next owner. In fact, in England, people often went to great lengths to hide land transactions from the government, to make them appear as though they were some other kind of transaction, because laws restricted how land could be conveyed, and dues were in order to the feudal lord or the king at every transfer. Perpetual trusteeship situations masked inheritance of land, and phony court cases over land titles were sometimes designed to allow conveyance of property from the defendant, the grantor, to the plaintiff, the grantee, even when the property had been entailed within the defendant's family. In America, on the other hand, there were land registries from the beginning. In some jurisdictions, they were maintained on a colony-wide basis, but most were kept at the county level. The clerk of the county court oversaw them. We have already discussed that process. The deeds were recorded in books along with other kinds of instruments like powers of attorney, deeds of trust, mortgages, property divisions, or bills of sale that people also wanted to memorialize. The main rationale behind recording a deed was to safeguard the title in case the original documents were lost or destroyed. Nevertheless, you must remember that a deed did not have to be recorded in order to be legally binding, and because there were no penalties for failing to record deeds until 1885 in North Carolina, some people just didn't follow through. Therefore, there are land transactions which occurred which have no public record attached to them. You can only deduce that they happened from other deeds in the chain of title, and some of them were brought in the 1880s and afterwards and recorded very, very late, maybe 50, 60, 70 years after they were originally executed. How are deeds arranged in deed books? They are recorded in the order that the clerk received them by term of court. They are indexed by both the buyer's names in a grantor index. The seller's name in a grantor index, and the buyer's last names in a separate grantee index. Exactly how the index is arranged varies a bit from locality to locality and from time to time. There are usually multiple grantor-grantee indexes that cover different periods of time. In general, in North Carolina, once you pick the index for the right date range, you consult an index to the index, which is called a set-out. Usually at the beginning of each letter or set of two consecutive letters beginning a name. It tells you on what numbered section of the index a certain surname is located. Each major surname will have its own set of pages, all with the same number as recorded in the set-out. And that's what you see here. Those names that are relatively rare in the county are placed together within the same section of the index in groups by the first three letters in the name. You check the mixed table of names, which you will see here, to find on which page these less common names appear. Once you turn to the correct numbered section, you will find that each deed is represented by the name of the grantor and by the name of the grantee. If you see the Latin abbreviation et al. Next to the index name, it's an indication that unnamed people of other surnames are also involved in the deed, either as grantor or grantee, depending on which index you are looking at. The given names associated with the index surname are placed in different columns based on their position in the alphabet. The date of recording is usually given, not always, and sometimes the actual date of the deed was executed as well. A brief description of the land, acreage, stream, road, or other landmark may or may not be included in the index, along with the type of instrument, whether it's a deed, mortgage, power of attorney, quitclaim, and most crucially, the deed book and page number. It pays to print out the grantor and grantee indices through the period you're studying for a surname that you're interested in. But if there are only one or two entries that catch your eye, you may just decide to copy out those particular index entries and look up the deeds from there. Remember that if the land was previously in a different county from which your ancestor's county of residence was later formed, you will have to look among the older county's records for the earlier deeds. Records are not transferred between counties when a new county is organized from an older one for the most part. The grantee-grantor indices do not necessarily include every instrument recorded in the deed books, but they should include all of those that have to do with land or real property. Other kinds of records dealing with personal property, crucially sales of enslaved people, may not be indexed at all. There are often old handwritten indexes in the front and the back of each individual deed book, and these are more likely to index everything in the book than the separate grantor-grantee volumes. You may find that some deeds were recorded long after they were actually executed, sometimes decades later in the 19th century. That's because a later owner may have decided to record all the old deeds in his chain of title when he purchased the place. And earlier owners may have neglected to record their own deeds, but the later owner decided to make up the deficiency to protect his title or her title. So where will you find deeds and deed indexes? Well, there are several potential places. You can go to the County Register of Deeds office and use the original records in the courthouse. Sometimes you may have to ask for some of the older deed books after you check the indexes. I've noticed that some of the actual deed books have been removed from the open shelves in the Register of Deeds offices to protect them. Secondly, you should inquire with your local library. You can check to see if anyone has abstracted, indexed, and published the deed books you want, so that you can have access to all the names therein, not just the grantor and grantee. The library is also likely to have at least the deeds for their own county on microfilm along with the indexes. It's sometimes possible, furthermore, to use your local library's interlibrary loan department to borrow microfilm of deed indexes and deed books from North Carolina counties via the State Library of North Carolina. This is a low-cost or no-cost option that is very convenient. The service can be surprisingly rapid as well. Thirdly, you might look online at the Register of Deeds office website for your county of interest. Some of those, at least, and more actually than formerly, have the old indexes up in digital format, and some have also digitized the old deed books themselves so you can go directly to the documents you want from the index, as long as you have downloaded the image viewer plug-in to your computer. Most of the counties have digitized their old deeds in North Carolina by now, and many of them have put them up online. A final option is to check the Family History Library catalog on the Family Search website. The Genealogy Society of Utah and the Mormon Church have microfilm mini deed collections from counties around the country, and by now they have digitized all of them. So if you have, for North Carolina anyway, except maybe past the early 20th century for most counties, before that most of them have digitized the deed books, and with an account you can go right in and look at them as if you were looking at microfilm, but digitized as images online, both for the indexes and for the original deeds. That's probably the easiest way for most people, and certainly for people outside of North Carolina. So, how can any of this help your research? There's so many ways. I'll run down a few of them and then give you some concrete examples in closing. First of all, you can establish locations in neighborhoods. This is an extremely important factor because our ancestors tended to group themselves in particular localities along particular creeks or roads. Their neighbors were often their kin. They often married into neighboring families. Sons and grandsons of the same ancestor often inhabited the same land or nearby land for generations. Sometimes location is all that will separate your family from a different, unrelated family with the very same last name. Location will also help you determine where to look for other clues, like nearby churches that may have relevant records, cemeteries where your ancestors or their kin may be buried, or neighboring counties if the land was close to a county line, where you may also need to look for records. You could track ancestral movements using land records. Since acquiring land was the first thing many people did when they first settled in a new area, and selling land was the last thing they did when departing an old settlement, deeds and grants help us to establish a chronology for a person, where they were at particular times. Sometimes deeds of sale in the old location or power of attorney recorded in a deed book can tell us precisely where they went after they departed that area. But at other times, if we find that the date of the last deed transaction in one place coincides with the first in a new place, it does help us feel more secure that the two individuals in the two different places are in fact the same person. And finally, and importantly, establish lineages. Sometimes the passage of land from one generation to the next is the only evidence we have to confirm the relationships between individuals. An actual deed, will, estate file, or land division acknowledging kinship may not even be involved, as I'll demonstrate a little later. For this reason, it pays to perform what I call a real estate analysis on every individual whose parents are uncertain or unknown to you, and whose wife's parents are uncertain or unknown. What do I mean by a real estate analysis? Collect all the old deeds and land grants by which an individual obtained property in the deed books, and briefly describe and date each acquisition. Put those in one side of the equation or column as inputs, then place all the land that the person sold in his lifetime by tract on the right side of the ledger as outputs, as it were. Also on that side, you should record each tract that was left or divided among the heirs. Try to draw lines between the tracts acquired and the tracts sold or left to heirs. Many times, you will find no record of purchase for some property that was later sold or devised to heirs. That property came into your ancestor's hands in some fashion, and it could be possible that it was inheritance from his side of the family or his wife's side. Tracking that land backwards in time, using its metes and bounds description might be your key to solving a relationship riddle. However, remember, once again, that not all deeds were recorded, and this circumstance could also explain the situation that I've just mentioned. Also, remember that the size of tracts could vary a bit from one estimate to another because of the inexact nature of metes and bounds surveying. And then finally, another thing you can do with land records is identify associates. Finding the names of all the people who have interactions with your ancestors is such an important exercise when you're trying to locate additional family members. Our forebears usually relied on their families and stuck close to them. I encourage you to consider the names of all witnesses and neighbors in land transactions, as well as those who served as chain bearers on grants, or who assigned their interest in a land entry to an ancestor as serious evidence. People who sold or purchased land from your ancestor may also be relevant. You will be rewarded if you make this a standard procedure. I like to collect the names of associates in charts, giving the place where I found each association and the date of the document in which they appeared together. You can create one chart for each ancestral associate and rank them according to the number of times they show up in other records linked to the confirmed ancestor, or based on the degree of risk, inconvenience, or intimacy indicated by the circumstances of those associations. Following up on individuals and families who appear again and again in these associate charts is a really effective way to pursue your research when you can't find direct evidence of a relationship. And then one more thing before I proceed to my example. You can get some age estimates from land records. Since acquisition of land is often one of the first legal transactions a young person might undertake, his first appearance in a deed might give you a rough idea of when he was born, particularly in the 17th or 18th centuries, when other indicators of age are rare. Young children could own land, but they would not usually buy or sell it in their own name without a guardian's assent until they reached the age of 21. Technically, one could purchase land from a minor, but this almost never happened because anything a minor person sold you could eventually be taken away and returned to him. As a minor, he was not legally competent to dispose of his property. We also know that legal witnesses had to be at least 14 years old. Now, here's a specific example to share. The deeds of Montgomery County, along with most other county records, were destroyed in courthouse fires right up to 1843. I had a Parker family living there from the mid-1790s. I knew that my ancestor Garrett Parker was born about 1774 and died in about 1829 with a will. The names of his parents were unknown to me. So I started collecting land grant data from land warrants and surveys because those records were kept in Raleigh and weren't touched in the courthouse fires. There were basically two Parker families in the county, one on the west side of the Yadkin River in what is now Stanley County, and one on the east side in the river in modern Montgomery. My family lived on the east side of the river. These land grant records that you see abstracted, along with their census appearances, basically tie them together and suggest that William Parker Sr. had at least three sons, Garrett Parker, John Parker, and William Parker Jr. How do I know this? Because of the names of the chain bearers and the location of the land. And the second example, this is from a wonderful atlas of Orange County, North Carolina land grants produced by Mark Chilton with the help of Stuart Dunaway. It's the first portion of a projected 4-volume project, which I think has been canceled, unfortunately, now, and covers the old Hawfield section of the county from Chatham County line to the Caswell County line. The second 2 volumes were anticipated to be produced, but I believe they've abandoned the project, unfortunately. The finished work was supposed to include Alamance and Durham counties. My Kate's ancestors lived in this neighborhood. My oldest confirmed patrilineal ancestor is Barnard Kate, who was born in the 1740s and died in 1826. But he is not the first Kate to arrive in this area. We believe that his father was Thomas, but Thomas died during a hiatus in Orange County records, and there's no proof of his children. His part of the map shows that Bernard Kate's land, this part of the map, shows that Bernard Kate's land was just adjacent to his supposed father and brother, both named Thomas. Many of the other neighbors were also my ancestors. Barnard married into the Sykes family. Barnard's son David, also my ancestor, married into the Workman family, and their land is in the same vicinity. I am also related to Smith and Thomas families that you see on this map. Neighborhood is so important in this endeavor, and these land grant maps can point you to who your likely relatives were. Now, land records that we haven't dealt with tonight relate to litigation of real estate. There's really no time for it, but there's a second lecture that will be coming up soon. I'll be posting here, prepared on that topic. These legal contests are, of course, filed among the court records, often those pertaining to the Superior Court and Court of Equity. They're oftentimes housed in separate series of papers or court rolls called ejectments or civil actions concerning land, and sometimes just mixed up with the general run of civil action papers or judgment rolls. These papers sometimes have wonderful testimony attached to them, and also include plats like this one that tells the story of my Orange County Cheek family. I've never found a document which gives the names of all the children of Robert Cheek, or which provides an exact sense of when he died. But he did own land, and I knew that. So what became of it? I didn't find out until I uncovered this court case. Again, no precise list of children, but many of the children were involved in this litigation and gave some testimony. And here are the details. In the case of John McCarroll versus Stanford Cheek and William Kirkland in 1823, among the civil action papers concerning land of the County of Orange in North Carolina. Now, Robert Cheek the Elder, according to the papers filed in this case, obtained a land grant the 13th of March 1780 for about 300 acres on New Hope Creek. But in 1817, his son Richard Cheek and his son-in-law Charles Jones obtained judgments against him for about $100 and 20 pounds respectively. The sheriff sold the land belonging to him at public vendue to John McCarroll, or public auction. In 1828, William Kirkland obtained a judgment from the court against James Cheek, Robert's son. The question before the court was, what part of the land did Robert Sr. rightfully own, and which part was owned by two of his sons, Robert Jr. and James? Apparently, in the 1790s, Robert Sr. had informally divided his land between himself and two of his sons, according to testimony. He'd actually had the dividing line surveyed and had taken purchase money from them, but he never made a deed to either. In fact, when he pressed his sons to have a deed made, they always put him off and said that he had plenty of time to do this. Actually, that wasn't the case. John Cheek, another son and my ancestor, gave the following testimony. Everyone was aware in the neighborhood that this division had taken place, and that only about 125 acres of the property was actually in the possession of the elder Robert. At the time the public sale took place for Robert Sr.'s portion, the notice described the land as that on which Robert the elder lived. When the purchaser, McCarroll, brought the deed forward to Sheriff Turner to sign, the sheriff noticed that it described the tract as 300 acres. He told McCarroll that this was not what he had sold him, that he had only sold the portion that Robert Sr. occupied, and that he must change the deed. So McCarroll changed the quantity of the land to 125 acres. He did not change the description of the metes and bounds, however. Because the metes and the bounds described the entire tract with the typical phrase 125 acres more or less, McCarroll thought that he could still claim all 300 acres. The Supreme Court of North Carolina reversed the lower court rulings and demanded that the land be properly divided in three, with the Robert Sr. tract going to McCarroll and the James tract awarded to Kirkland, and James's Cheek's tract awarded to Kirkland as purchaser at public sale. The interesting part here is that there had for a long time been a controversy about who the father of this Cheek clan was. In fact, it had been in print for some time that his name was James Cheek Sr., but this was largely because there was neither a will nor an estate file nor any recorded deed that proved any of the children of Robert Cheek Sr. The answer was in a court action, to whom only one party was a Cheek, and it was not one of Robert's children, but one of his grandchildren. I hope this survey of the detailed land records can afford will inspire you to make your foray into this area of research. There's no question that following the land can reveal relationships and details about the lives of your ancestors, but better still, it can enhance your understanding of the geographical spaces in which your ancestors lived and show how neighbors and relatives interacted with one another. A holistic approach to genealogical sources can bring your research closer to the realm of history and render a bare series of begats, names, and dates far more interesting.